My name is Dennis McAndrews. I am the founder and managing partner emeritus of our law firm, McAndrews, Mehalick, Connolly, Hulse and Ryan. Uh, this is the first in a series of MLO minutes, short videos with regard to tips to developing an appropriate IEP. I would say at the outset that all of these 10 tips that we're going to provide in these videos are important. And every one of them is a building block in making certain that a child with disabilities has a true, free, appropriate public education that will allow the child to make meaningful educational progress. So we're going to have these short videos, a series of 10 of them, that will come out over the next several weeks, maybe a couple months, to try to give some guidance to families as they navigate the special education system. We have a wonderful group of attorneys and paralegals and assistants who work on these special education cases. Our initial uh, conference and record review is free. Almost all of our cases are handled on a contingency basis where the family does not pay us a retainer and does not pay hourly fees, but rather we secure those fees from the school district or the charter school upon a successful settlement or a successful due process or federal court matter. So we are very much excited and interested in any feedback that you have as well. So please don't hesitate to reach out to us on our contact us part of our website of mcandrewslaw.com for any feedback, or if you have an issue that you'd like us to review. We are certainly happy to receive your records, review those records, and have a conference with you. So the first tip that we're going to talk about today is what I call start early. The great basketball coach, John Wooden, often would tell his players, failing to prepare is preparing to fail. And the sooner that you begin preparing for an IEP meeting, the better. You can't expect to walk into an IEP meeting the morning of it and without having preparation. The most essential component in preparing for an IEP meeting is having really good evaluations, really strong progress reporting. And we're going to talk about progress monitoring in one of the subsequent videos, but make sure that you do have a comprehensive evaluation. Under the federal special education law, whenever a child is suspected of having a disability, that is when the child find obligations of the school district begin, and that's when the evaluation process must begin. So it's very important to have, in effect, a powerful and comprehensive evaluation so that the true needs, the global needs and strengths of the child are known, because we not only need to know the needs, the areas where the child needs to make improvement towards independence and self-sufficiency, which is the goal of special education. But also we want to know the strengths, because you not only focus on needs, but you build upon strengths. So a comprehensive evaluation looking at cognitive skills, achievement levels, behavioral functioning, social functioning, if there are physical issues, that those are addressed. And oftentimes school districts will try to claim that medical evaluations are the sole obligation of the parents for things like ADHD or for speech language as a prelude. But where a medical evaluation is necessary to create an appropriate IEP, the school district must also participate in that, must also, if necessary, undertake it themselves. So we really do need to know the pattern of strengths and weaknesses of the child, social functioning, emotional. And if the school district has not undertaken a truly comprehensive evaluation, or you feel that the evaluation does not touch upon all the needs of the child, a parent through us or on the parent's own, can request an independent educational evaluation for an evaluator at the choice of the family, often in consultation with us, that the district must pay for. And the district can, if it chooses, contest that, but it is their obligation once a parent or us requests an independent educational evaluation with an evaluator of our choice, not an evaluator from a list the district provides, but an evaluator of our choice. And we have multiple evaluators who are just outstanding to get to the crux of the child's issues. If the district chooses to contest that, the district must ask for a due process hearing within 30 days, and the district must establish that their evaluation is truly comprehensive, is truly accurate, and will provide everything that the child needs. That's a very powerful tool, and the overwhelming majority of cases in which we are involved in where we ask for an independent evaluation, we obtain that independent evaluation and the district grants it. In fact, it is typically more expensive for a district to contest the evaluation than to grant it. You can never know too much about a child either. And having that independent evaluation almost inevitably provides additional insights into the child's needs and how the child can best progress towards that goal that the special ed law is very clear about of moving the child towards independence and self-sufficiency. And one other quick notation before we wrap up this commentary. We get a fair number of cases where a child who's never been identified is being subject to discipline, often suspension or expulsion, maybe for something like fighting, getting in conflict with teachers or staff or other children. And in those cases, we typically ask for an independent educational evaluation. And in those cases where the child has never been identified, because once they're identified for special education, the ability of a district to simply expel the child is very, very limited. And in the overwhelming majority of those cases where the child, and sometimes they're in high school, is getting an evaluation for special education for the first time, in somewhere about 90% or more of those cases for children never identified, now have discipline issues, the evaluation shows that they have a disability, that they are entitled to special education. And in those cases, we're often able to obtain compensatory education for the child and an appropriate program to address whatever the underlying source of that issue is. And remember, in those cases, schools have a tremendous incentive not to identify the child. They'll have to program for them. They'll have to probably provide compensatory education for failing to identify them before. They will have to pay counsel fees to their own attorney, to our firm. So even though there's an incentive not to identify, those standardized tests that are given by the school psychologist far more often than not show that there is a disability that has never been identified. So again, start early. Make sure before you get into the IEP process that you've got a comprehensive evaluation. If you do, great. But if you don't, and you feel that even with an older evaluation that you don't have additional information which is necessary, you can always ask for another evaluation, can ask for an independent. There are many tools available to us to make sure that every child receives that appropriate education towards independence and self-sufficiency and meaningful progress that they deserve. Thanks, and we'll see you at the next video.